Good afternoon, everybody. Welcome to our School Change webinar. Today we have with us Liisa Stern from Hirsch-Schramm Law Firm in Oakland County, and we are so excited to have her here. She's done a lot of school change cases over the years. I think most everybody here knows Liisa already, but she's been practicing law for 24 or so years, but she really dedicated herself to family law about 15 years ago. So she's had many opportunities to work on school change cases, and she's in the trial court a lot. So she has a lot of input to share for us and advice for all of us dealing with school change issues. Now, just a couple of quick reminders. There is a chat button, which you're more than welcome to use. Everybody can see the chat. Lisa's not going to be looking at the chat at all because she's got to focus on talking, but I'll try to monitor the chat to make sure if there's questions that people put in the chat that we can share those questions with Liisa and see what she says. And there's also a Q&A button. And that's just a different way of submitting a question. I think the Q&A button only Liisa and I can see. I don't think anybody else can see it. So if you want everybody to see it, you know, feel free to do a chat, but that's how we're going to do it. And we're just going to go to 2 o'clock. And then remember, after today, we'll be sending takeaways sometime next week, just to kind of give you the highlights and send out the recording again if people miss part of it. I don't know what happened to Liisa. She disappeared.
I'll be right back.
Oh, good.
Sorry.
That's okay. So I hear her, but I don't see her.
I have to tell people not to text me because it's
oh yeah. I put my phone on silent, and I had to turn off my email because it's like super distracting. So welcome, Liisa, and let's just jump right into it. So we're going to start off by talking about some tips for trial attorneys who are pursuing a school change case or defending a school change case. Let's talk about first, like, documents that you can use to help your client's case, whoever you represent.
Okay, well, hi everyone. Like Liisa said, I can't see who you are, but I probably know all of you. And when Liisa assigned me this topic, I was like, oh, because it's not a sexy topic. It's but it's something that we all have to deal with quite frequently, especially now because the courts are tending to do a lot more 50-50 custody parenting time arrangements. But as far as documents that are concerned, it's actually a really good point. Documents that people do, you're going to go online and you are going to find school comparisons. So let's say your client comes to you and says that she's living in Walled Lake, and she and her ex-husband live in Walled Lake, and she wants to move to Birmingham, and it'll be a change of at least district. Let's just talk about school right now, not custody, not parenting time. The first thing you're going to do as an attorney, or she could be moving to, Macomb County, it doesn't matter. First thing you need to be doing is going online to look at school rankings. So I always look to the school rankings to see how the schools ranked. However, the real question is, and the real fallacy or the flaw, the most error that attorneys make is assuming they get these school rankings and they're going to run into court and they're going to use this as their exhibit number one and show it to the judge. Well, your exhibit number one is hearsay. It's going to be inadmissible to the court. So how do you get around that? Well, the reality is that there is an exception to hearsay, MRE 803-20. It's that catch-all exception, and we're looking to reliability of a document. So if it is a government created document telling us about, so the state of Michigan always, every other year, I would say, puts out online a school ranking. And if it's a government created document, it meets the indicia of reliability and it is no longer hearsay. But a lot of attorneys love to run to court with School Digger. I don't know if you guys know School Digger. School Digger is a website that most of us all go to because you get the 5-star review, what the parents say. That is all hearsay. And if you are defending, or if you're someone that's opposing the attorney trying to bring that in, you're going to object and prevail on your objection.
So Liisa, I mean, School Digger might be a useful tool if your client's trying to figure out, hey, which school is going to be better, if they're just trying to do their own independent research, right? But
it's perfect for a parent.
What's going to be usable in court, and using the state of Michigan website, and I think you said 803 sub 24, is that correct?
Exactly right. So if someone objects that it's hearsay, you argue 803 sub 24, that it's a government created document. There is an indicia of reliability and it will be admitted. Should be. I shouldn't say will.
What about information that comes from a specific school's website? Is that considered government information if it's a public school?
It's not. But this is what I do in every case. And I think a lot of attorneys fail to do this. I always have someone from the district there to testify. The best way to do that, and I was talking to Lisa about this ahead of time, every school district has an attorney. These districts all have attorneys that work for them. If you contact a teacher, you contact a principal, so I'm going to be blocked out, and you ask about if they want to testify, they're going to say, no way. We don't want to do it. We've got to talk to our attorney. What you need to do, first of all, is find out which law firm, which attorney represents the district. The attorneys are very helpful. They will explain to the teachers what it is that you need, what it is you're looking for. They will explain to the teachers, when they need to be to court. They basically are your liaison to the teachers. So I always try to go through the lawyer assigned to that district, or the lawyer that works for that district. I find that to be very helpful. And I also find that the judges almost hang on every word of these people that come in from these school districts. It's one thing to turn in your rankings. You've got your report. It's not hearsay. You're getting it in. Okay. Judge is going to look at it later, but it's a whole other thing if you have someone there like a superintendent or a principal that's going to discuss how great their school district is, or why this child should attend their school.
Does the judges not perceive that as just a rah-rah? We're just like, of course they're going to say nice things about their school.
You'd be surprised, Lisa, that they tend to take a lot of their language and put it right into their opinions. A lot of the things I hear.
One thing I think I've seen come up, and this is really relevant to this whole showing how great the school district is that you're proposing to move to. But I remember in a change of domicile case, Yachik versus Yachik, which is a published opinion, the mom wanted to move to Pennsylvania, and part of her case that she put forward to show why the move would be a benefit to the child was to show about how great of a school the child would be in Pennsylvania. And one of the failings that both the trial court and I think the Court of Appeals observed in that case was that, okay, well, there's no question this Pennsylvania school is going to be awesome. Like you can't argue with it, but there's nothing to show us that there's anything wrong with the school where the child is now. And this was like a Northern Michigan school. So we had, the local judge supporting the local school, and then but the Court of Appeals affirmed that analysis. So I think, as part of your comments, Lisa, I think it's probably going to be important to show like you said, the comparison, not just why the new school that you're advocating for is so great, but like how it really compares with the old school, and really apples to apples, right?
Well, yeah. And I think
data to compare the two.
When I think, Lisa, part of the issue is just because a school is good doesn't mean it's good for that child. So what you have to remember is these are factually based cases here too. What are the facts involved? Is this child a special needs child? Is this child a gifted child? What are we looking at? So where a school district may be a great district and a perfect school for a child of average to higher than average in intelligence, maybe they don't have the support system in place for kids with special needs. So the reality is, don't forget that you have to look at the child or the children that are the focus of the case. And not only academically, but as far as activities are concerned, extracurriculars. Do you have children that are very involved in school sports? And one school has a swimming pool and that child can continue on in swim team. But if they go to school Y, that school does not have a pool. That can be a deciding factor. You're looking at these specific children.
Absolutely. Now, what about using report cards?
Report cards, I don't use that much. You can use them to show that the kids, again, to say that if they're gifted or if they have special needs, maybe they belong at a STEM school. Maybe they're a child that does really well in certain academics and we want to really build on that. Then I would use a report card. Other than that, it's not going to come into play.
If a child's struggling, I mean, is there an argument that potentially could be made that they're struggling and the school's not providing the assistance that is needed, but this new school that we're proposing could maybe offer more assistance to the child?
You definitely, that could definitely be an argument that could be made. The other thing is the child being, a lot of times I hear a child is being bullied. Not a lot of people want to remove a child from one school because the child's being bullied. And so that's something the court's going to have to look to, but you're going to need evidence of all of this. These are allegations that you need to be able to prove going into court. So if you're going to claim a child's being bullied, there better be some kind of a paper trail. Have you gone to the teachers? Has the child gone to the teacher? Have you gone to the administration? Have you tried to work it out with this administration? So you can't, it's premature to rush into court. If a client comes in saying my child's being bullied, the first thing you want to advise them to do or take the steps necessary to work it out with that school.
So Kristen asked a question, which I definitely want to cover. So I think this is a good time to do it. And you intimated it earlier, Liisa. So many judges now are doing 50-50 parenting time. Well, what does that mean when it's a young child and they're week on, week off with parents that maybe live, maybe not right next to each other. Maybe they live a little bit of a distance away, but then somebody, at some point, this child is going to be 6 years old or 5.5 and is going to start kindergarten or maybe even a preschool issue. And this is where I see cases over and over again where the judge has to decide where is a child going to start school. And we will get to the whole how a school change might affect parenting time and custody. We will be talking about that today as well. But I don't know if you have any special comments to address with the whole, like, is it different, your case different when you're doing the whole, this is the child's first school versus a modification?
It is somewhat different because you don't have the history. So you don't, you may not even know if a child has special needs at that point, if they're not severely, disabled. You may not know if your child is gifted. Really, then you are looking more to which of those two, what districts you're looking at. You're not just picking your favorite district. Which of those two districts is based on rankings the better district. And I tell people all the time that are getting divorced and it's 50-50, unless you live in the same school district, if you're going to move, you better know where you're moving to. You better be doing your research before you choose to move, because you are going to end up in a situation where the court may have to choose a school. And at that point, I find that they primarily have to look to the ranking.
So have you seen a situation where the parents, with a young child don't live in the same district, maybe they live 2 districts apart? Do you recall any instances where maybe the judge ends up picking a school in the middle that's not the parents? I'm like, I guess you can't necessarily go to any district, so that's another issue. But
you can. A lot of the districts now are, you can get in their what are they called again? Their school choice. Thank you. It escaped me. So a lot of these districts are school choice, and I actually have had judges do that a handful of times. They look to a middle spot. I don't know if that's the right or wrong answer. I understand the compromise. It's obvious, but to me, there are some downsides to that. But yes, you can sometimes start off a trial thinking you're fighting about sending your kids to school in St. Clair Shores versus Troy, and they end up at, something right smack dab in the middle. So that's the other thing you have to warn your clients. When you take something to trial, you lose control of the outcome.
Right. Let's talk for a minute about witnesses. And you already mentioned somebody from the administration of the school to talk about the rankings of the school and how great the school is. Let's talk about other types of witnesses that you might put on. Obviously, the parents very often testify, so that goes without saying. What about bringing in the teachers? And I wonder how much do teachers hate having to come testify in court? I'm guessing it's not one of their favorite things to do.
So I actually don't bring in the teachers that often when I'm looking to do a change of school. I find that they don't have the knowledge about the entire district and what the school offers in totality as much as a superintendent or an assistant superintendent. The other thing is you'll find when you're working through the school's attorney, they are remiss to pull a teacher out of a classroom. If they can avoid taking a teacher away from his or her job, they will. And like I said, they can speak to that child and that child's academic progress, but they often will tell me, I cannot speak with any kind of authority to the district as a whole.
So I think it would be more likely relevant if the child is, well, if their child's doing really well, you should be able to show that with a report card.
Exactly.
But if this child's struggling or has special issues that are, maybe the teacher would be concerned about the child changing schools, for example, because for some kids change is really difficult. And so it might affect one child more than another child. So that may be an appropriate time to have a teacher testify.
Yeah. And
oh, go ahead.
No, because I just would tell everyone that don't have the teacher there instead of someone who can speak to the district as a whole. You can have the teacher there in addition, but don't substitute it. That you're not going to get the testimony that you wanted or you needed. Got
it. So when when telling the client's story to the court, and this comes out through emotion and at the hearing, how do you go about telling the story in a way that's going to be impactful or persuasive? I mean, because some parents just, maybe they want to change schools for reasons that are not good, but other parents have maybe really compelling reasons to change the school. Doesn't mean it's going to get granted, right? But let's talk a little bit about telling the story to, maximize the chance of your motion being granted or getting the other side's motion denied if their story is not very good.
Well, I think that's really motion preparation. So I think what you want to do when you first meet with your client is you got to meet with the client. You got to take voluminous case notes. You got to go through and organize everything before you submit anything to the court. Obviously, that's going to also help you to identify key witnesses that you might need to be calling through the case. But I tend to find that you really need, I mean, in this day of Zoom, this is all we can do, but I prefer this face-to-face meeting. You really need, if you can have one, a face-to-face meeting with the client and take some time to really understand the entire story. There are things that you're going to want to use in court that the clients don't realize that you need, that you're not going to know about until you really take the time to have them just go and tell you their whole reasoning for what they want to do. You got to weed through what needs to be, submitted to the court or not. But I think most of you attending, I can't see your names, I think anyone here is probably pretty well versed at motion preparation.
Right. And then, I think a comment that you made to me the other day was that the school change needs to really be for the benefit of the child. And where I see it come up a lot of times is in a domicile context. And I'll just go back to the Yachik case as an example, where the mom had some very, very good reasons to move to Pennsylvania. And she showed that there was a very good school available in Pennsylvania. But really, how does that benefit the child? Like, that's like it comes down to the wire. It's not about how it's going to benefit the parent and make the parent's life better. How is it really going to benefit the child? Even if it's a better school, doesn't mean that it's necessarily going to benefit the child to be pulled out of one school system and put in.
I mean, just like everything we do in family law, child-centric, child-specific focus. It has to be the key.
You mentioned earlier about the example of a bullying issue. How do you feel about bringing in, like, if there's a child therapist or something like that as a witness to establish how the bullying might be affecting the child?
Oh, absolutely. And a school social worker. And that, again, is something that you're going to find out through your discussions with the client, is child and therapy.
Is that like the school counselor, or are those
no?
Two rules?
There are two different things. So a school counselor is someone who helps you pick your classes or make sure you're on the right track. Usually those are more high school level. Every school used to be, back in the day where there was money, there was a school social worker in every school. Now these social workers float from school to school. So there's one that may be assigned to 3, 4, 5 schools. But typically, if you have a bullying problem, if a child tells a teacher they're being bullied, or that they're having issues, or they could even be having issues at home, that's what the social worker is there for. They will have the child meet with the social worker. This is not someone who helps them with their academics. They're a true social worker who will sit down with the child to figure out what's going on and what he or she can do to help.
So would a parent know if they're like a parent with legal custody? Let's just assume joint legal custody. Would a parent be told when the child's talking to a social worker at school?
Not always.
So, because one of the things that I was wondering, we have parents with joint legal custody, but maybe one of them's the non-custodial parent because they only have weekends. And how much information are they going to know about what's going on? And with the school administrator, if you get that, get in the conversation with the attorney for the school district, obviously the school records should be available to the other parents, regardless.
Exactly.
Even if they don't have joint legal custody, I think, get access to the school records.
Yes, you don't need joint legal custody to access the records. There's a difference. They can't make the decisions, but they can access the records. And the records should reflect if there are meetings with the school social worker.
And so here's a question: to get those records, especially if you're the non-custodial parent or even a parent without legal custody, can you just write a letter to the school or call up the school and ask for it? Or is there a special FOIA, or how do you get them? I feel like sometimes the schools are, and this goes to medical information too, because the same rule applies, the same statutory provision applies. But I think sometimes doctors and teachers or school administrators don't really understand. And I'm not talking about in bigger districts. I think that they have more legal advice coming to them, but in smaller towns and smaller districts, I don't think they really understand that even if you don't have legal custody, that you still have a right as a parent to have access. So what's the best way to get that information if you're a parent? Or is it doing
I've had that happen so many times, I can't tell you. And what I do, if they don't want me to be involved, just because they don't always want an attorney, I give them the statute. I have them take the statute with them to the school, and I have them recommend very nicely that if there's any questions about it, that they contact their attorney to make sure they're looking into it. The schools are incredibly difficult to deal with. They do not like to give a non-custodial parent records. So yeah, you give them the statute now, and if they involve you as the attorney, I will typically write a letter and citing the statute and asking that the information be released.
So I'm guessing that the only way that a school could legitimately refuse to share that is if there's an order in place that says this parent is not permitted to get these records.
Exactly right. It has to be through a court order.
Very often.
I've never had it happen, but I know the answer, and it is only through a court order. Yes.
And even though I only do appeals, believe me, this issue has come up so many times where my clients, we're in the middle of an appeal and the client's telling me, I want to do this or that, and they're not cooperating with me. I'm like, well, there's a statute. And then exactly what you said, print it out for them, or make them print it out and bring it to the school district or the medical provider. Do you have any special tips? So we've been talking mostly about how to pursue the motion when your client wants to advocate for the school change. Are there any special tips that would apply to defending such a motion?
It's the same thing with the other side of the coin. Show that the child, again, you're comparing the schools. Child-centric is the move going to be best for for your child? Can you show how your child's progressing in the school? A lot of times the friends, your child, if the child's already been in school, if it's not the first year, your child will hopefully have, or the child of the parties will hopefully have made a lot of friends, be comfortable in that environment. Liisa, actually, you talked about a teacher coming in. A lot of times the teachers will come in and say, how that child is doing well and socializing, and that the change would be difficult for the child. And honestly, this is what, as an attorney, you're not making friends, but at the end of the day, object. A lot of times people are trying to get in hearsay when it comes to a change of school, and don't let them object, cut them off at the knees.
Yeah, absolutely. So one really big topic we need to tackle, because this is, well, there's actually two big topics. The timing of the motions. And so what I see over and over again is the parent wants to have a school change, and then by the time they get a decision that they're unhappy with, it's time for the school year to start, and the appeal is going to be occurring while that new school is in place, and it's almost impossible, not impossible, but almost impossible to get a stay pending appeal. So from your perspective, though, let's talk about the timing of getting that motion filed, and how to move the case through the trial court.
most of these motions are filed early spring. And that is just the reality. I mean, March, April. Yeah. I mean, April latest. If they, they know about it, I typically try to time it. So, the parties are aware, my client is bringing me, wants to file a motion. I try to do it March or April. And then what happens, as you guys all know, is in the summer, the courts are inundated. They have all these, hearings that they have to change schools. And the reality is, I agree with Lisa, and I've never thought about until getting ready for this seminar today, was the fact that if there's going to be an appeal, the child is going to be ended up staying where they are. The order of the court is going to be in play and for the entire next year. But I still, Lisa, I'm a big believer. I'm just stuck in my ways. I file these motions early spring.
I mean, is that just because that's when your clients bring it to you? I mean, if you had an opportunity to file it in December, would you, or?
I would, but sometimes I feel like the courts almost say, well, it's too soon. It's not ripe. It's not, so you're kind of stuck in the middle, you got to make sure it's a ripe argument, but give yourself enough time that you're going to get a ruling before the school year starts.
So I was thinking, oh, go ahead.
Now say you appellate attorneys have to figure the rest out.
I can share some thoughts on that, but in a minute. So I was thinking of maybe some techniques to help move things along faster in the trial court. If there was agreement that you can make with the other party about, like if there was any facts that the parties could agree on, so that maybe the evidentiary hearing would be slightly more limited, or if there was an agreement as to exhibits, which is, applies to any trial. But with the school cases, like, do you want to spend an hour of, a full day or 2-day hearing on getting exhibits admitted when, you could, kind of get this moving a little faster by, communicating with the other attorney? I don't know if you have any thoughts about any techniques to use to get it to go faster than the normal, course of just waiting for your hearing.
I don't know there's much you can do. And the problem is, we all like to mediate because you can probably mediate a case, a lot more quickly than you can try a case. But these are usually zero-sum cases. Someone is going to win, someone's going to lose. I mean, unless you have parties that really are willing to consider a middle district or a school that's located within the middle of both homes. But so typically you are waiting for the court to just schedule the hearing. I don't know about anyone else's hearings on these cases, but I don't find them to go more than 2 days. So you're not talking weeks and weeks and weeks of a trial. And usually, maybe I've just been lucky, I'm knocking on wood over here, I don't find they get broken up the way the judges do it with a custody case, where you get a half a day here, a full day there, 3 weeks later, you're getting another day. I find that they know that there's a timing issue on these, and then they'll give you a full day or two of their calendar.
So what about, do these types of issues go typically before the referee first, or is it just depend on the county, or is it something that usually the referees don't deal with?
It actually, I think what the front of the court is set up to do, it's my opinion that it probably always should go to the referees. However, every county is different, first and foremost. So know your county. And secondly, because they are time sensitive, Lisa, I do find that a lot of times they do just allow you to skip the referee hearing, and they'll let you go right to the judge. And because they're also, even the court is also sensitive to the fact that there needs to be a decision before the start of the school year. So.
Right. Can you address, handling client expectations or framing client expectations?
Sure. I think the first thing, most of these clients have already gone through a divorce or custody and parenting time case. Mm-hmm. And so they already think they know the system. And when they're coming to you, they want you to file a motion to change schools. So they think it's a Wednesday morning motion, a Monday morning, Friday, whatever district, whatever, county you're in, you pick your day. So the first thing you have to explain to them is, no, you're going to have a hearing. So there is going to be a hearing on this. So first of all, it's going to be more expensive and more time consuming.
Right.
What's that?
Evidentiary hearing.
Yeah. Yes,
exactly. It's not just an argument hearing.
There's a full evidentiary hearing. So you let them know that. And to be honest, if I always, before I file any motion, I don't know every school district in the state of Michigan. I don't know if they're good, bad. I don't know about specific schools. I don't file anything until I've done a little bit of due diligence. And I look on my little favorite school digger and I go to the school rankings. And if I don't think that the client is going to win, I don't take the case. I don't take the case. They'll find another attorney to take it. And then even if I take the case, I still explain that, this is not a guarantee. We can never guarantee anything. And especially when you're moving a child from one school to the other, that the reality is you're really going to have to explain to the court why we should take a child out of their current environment that most kids do pretty well in, hopefully, and put this child into a new environment. So, and then like Lisa, we haven't even discussed, but in the back of my mind, I'm sitting here going, and does it change the custodial environment?
That is the elephant in the room.
Exactly. I'm screaming out loud.
That is our next topic. Never worry. And it actually impacts a lot about how the case proceeds. And I was going to say something about appeals, but I really think we should talk about this issue first. So there's been a lot of cases, published opinions, and we'll make sure we'll talk about them today, but we'll make sure to include them on the takeaways. And I think the issue is that, does the motion to change schools, as Lisa said, change the established custodial environment? And if it does, if it does change the established custodial environment, there's one set of processes to go through. And if it doesn't change the established custodial environment, it's a different track that you go down. And as I think many of you are aware, the Michigan Supreme Court case in Piran versus Piran sets forth the standard. I don't know, Lisa, how conversant you are if you want to talk about it. But I welcome if you have thoughts about it, but I can lay out the standard if you want.
Go ahead. No, you can do it. I actually have it in front of me. So if you get something wrong, I'll stop.
Oh, good. Excellent. Thank you. So in the Piran case, the mother wanted to switch schools to Howell from Grosse Pointe, where the dad lived. And the issue for the court, and I believe the court, I can't remember, right? I believe the court granted the school change. But when it got to the Supreme Court, and Scott Bassett was on that case, and I don't know if he's here today or not, but the issue before the court was, did the trial judge in Wayne County go through the proper analysis to allow the school change? And so what the Supreme Court did was lay out this test. So it said, first, you have to look at whether the change of schools is going to change the established custodial environment. If it does, then you have to have clear and convincing evidence and go through each and every one of the best interest factors to determine whether that school change should be allowed or not. And if it doesn't change the established custodial environment, then you only need a preponderance of the evidence, and you don't have to go through all the best interest factors, just the relevant ones. So it kind of changes the whole examination of the evidence. And I think if I recall, there were some mistakes that had been made. And I think, if I recall, I think the Supreme Court thought that it would potentially change the established custodial environment, but but that really laid out the test for us, and that we use, all the time for all our cases, and it sets the burden. And so here's the question and I have a couple other cases I want to talk about too, but for Lisa, when do you have that conversation with the judge? Because obviously it changes everything about how the judge looks at the case, whether it's clear and convincing or preponderance, whether you have to go through all the best interest factors or just some of the best interest factors. So when do you put that issue before the judge? Do you do it early in the case so that you know how the judge is going to look at it, which might also impact your presentation of evidence? I would think if you know it's a clear and convincing standard, you might know that you have to get more evidence in. I think a lot of times it probably happens after the fact, but Lisa, share your thoughts.
Well, no, it should actually happen initially. It should be in your initial motion and brief. So if you're filing the motion, you're clearly looking to change, and it should be part of your motion, and it needs to be briefed as well. You need to spoon feed it. And I'm not saying these judges aren't bright, and I'm not saying they don't know, but that's our job. Our job is to spoon feed it. Our job is to spell it out. So It needs to be in your very first pleading, Lisa.
Well, and I think you make a really legitimate point, because even with judges that we have that are experienced in family law, and a lot of them aren't, but they have a lot of cases on their docket and they're dealing with a lot of different issues, even if they're a dedicated family law judge. And they also have law clerks who maybe, haven't worked very long in family law. So, I think what you call spoon feeding is really just really a good practice tip, because you want it to be very clear and all that. And then you got to get the ruling, right? So if you think, for example, if you want to make let's just use the Grosse Pointe Howell comparison. If you're the moving party and you want to say, you know what, this is not a change of the established custodial environment because, dad only sees the kids on the weekends. And in that case, I think he would go into the schools and he'd volunteer and he'd see them. There's a lot of involvement with the schools because it was really close to where he lived. But if you're the mom in that case, you're going to want to make the argument early on that it's not going to change his relationship with his children. And then you get a ruling on that early on as well. So do you actually do that at do you have an initial hearing on your motion and then you schedule an evidentiary hearing? Like, what's the typical practice?
Yeah, the first thing, and that's what you do to explain to the clients how it works. First thing you're going to do is have a motion hearing, but you're not going to win or lose. The court will then schedule the evidentiary hearing at that point.
So how does a judge know whether it's going to change the established custodial environment without hearing the evidence about the family and the schools?
Some judges will make that determination at the initial motion here when you're there for the first time, when you're just arguing your motion. That's why you want to make sure you have it briefed. You have everything flushed out for that first. Don't just go in with the skeletal motion saying, well, I don't need to worry because I've got my evidentiary hearing. Put it all in there, because there are judges who are going to say at that time, I find this is going to be, a change to the custodial arrangement, and counsel, I'm letting you know right now. But Lisa, it's a good question. I think part of the argument to changing the schools is part of it, if it's going to be a situation where one side is changing the district, the established custodial environment, the other side isn't. I think that really takes place at the hearing in of itself. It's part of what you're doing. A lot of times you're not. There are many times people are going to stay close enough together that even if it's a change of school, we know for sure neither side's arguing that it's going to change the custodial environment. Well, that's nice and easy. But in a case where one of the two sides argues it's going to be a change of custodial environment, that is part and parcel of that evidentiary hearing.
Yeah, and I think with the Purin case, I want to say it was around 65 miles, which doesn't sound like a lot. But it is if one parent was actively involved in the school, and then if you consider the traffic patterns between Howell and Grosse Pointe and how long it's actually going to take to get from one school to the other. I think it's probably easier when, if parents are 50-50 parenting time and both parents are involved in school and then one school is pushed much further away. I think that's an easier case to say, yeah, it's pretty clearly going to be a change of the established custodial environment, versus when you have like a sole physical custodian, the other parent maybe just has weekends, that may be the other side of the coin, I guess. But it's really going to be up to the judge to decide that. So that brings us to the Lieberman versus Orr case, which started as a school change case. But and that was between St. John's, which is just north of Lansing, in Midland, Michigan. Because the dad wanted to change the schools. And there were some arguments about how the child was struggling. One of the children was struggling in school, and that the schools in Midland would be better suited, and that he would be able to be more involved with school. And he couldn't do that now because, St. John's and Midland were too far apart. But the opinion ended up turning on. So what happened in Lieberman versus Orr, and this is the case I was on representing the mother, and Scott Bassett on appeal represented the father. So Scott and I go against each other all the time. But the judge made a parenting time modification because it was a school change and parenting time modification request. But the school, if I recall, the school change motion was what got things started. Mm-hmm. And the judge basically said, well, the current parenting time is, mom has 225 days overnights a year and dad has 140. I'm just going to flip the schedule. So the kids can go to school in Midland. Now dad's going to be 225 overnights and mom's going to be 140, but that's just flipping the schedule. It's not really a change of anything. It's just, a flip. So she granted the school change and then flipped parenting time. And so the whole issue with the opinion was that the Court of Appeals said, that's a change of custody. That kind of change is a change of custody because it was significant in how it, bore on the relationships with the parents that each parent could have with the kids. So with that in mind, this actually brings me to a point. And do you have anything you want to share about that? And I think you've probably seen these cases. So first, let's talk about like your experience and observations with those kind of cases where a school change does change the established custodial environment due to the parenting time modification.
Yes. What exactly do you want me to say as to it?
Oh, no, if you had any observations, just to share them.
No, but if I could speak to Lieberman versus Orr, I think what was interesting was almost the dissent. Did you read the dissent in that one?
Well, I remember it because obviously I won and I didn't really care what the dissent said. But yes, Peter O'Connell had a lot of things to say.
But it's very interesting to me as a practitioner. I looked at this as a clear change in the custodial environment. But it was very interesting there was at least a lot of thought, I think, put into it by the judge. I don't think it was a quick decision. And it was funny. I didn't see the perspective at all until I read the dissent. And that was the interesting thing. I was blinded really to the perspective. Right. Until I read the dissent. And then, so I actually, you guys, if you haven't read the dissent of Lieberman, I know it's not the law. Please don't think that it's the right decision. That's not what's guiding us. But I think it's interesting to read the dissent just to understand a little bit of what was going through the judge's head. And the reason I think it's important for practitioners to do that is because it almost helps you, if you understand what a judge might be thinking that would be flawed, it almost helps you guide your case to make sure that doesn't happen to you.
Yeah, that's a really good point, Lisa. And, sometimes dissenting opinions, I mean, there's certainly been many occasions where I am more fascinated by the dissenting opinion than I am anything else. And I'll just use a recent example. It wasn't my case, but O'Brien versus D'Annunzio, which was recently argued in the Michigan Supreme Court. And I'm totally in love with the dissenting opinion by Elizabeth Gleicher. But, that's just, I think when judges write dissenting opinions, they do put a lot of thought into it. There's no question that Judge O'Connell put a lot of thought into his dissenting opinion. Whether I agree with it or not, I don't. But, he put a lot of thought to it. And as a matter of fact, that argument, I don't think argument changed the outcome, and it very rarely does. But that oral argument was very lively. The judges all had a ton of questions, and it was really a lot of fun because Scott and I, both having the background as we have in family law, him way more years than me, but we were really having this conversation with the judges and answering their questions and putting forward our view of the case. And it was really, I think, a very productive example of an oral argument, but most of them are not like that. So the thing I wanted to point out is with appeals, the current court rule says that for post-judgment modification, it says that an order granting or denying a change of legal custody, a change of physical custody, or a change of domicile is appealable by right.
Yep.
Absent from that list is a school change.
Yes.
So if you have a school change motion, arguably, you won't have an appeal by right. Now, what I would do personally is if that school change does impact the established custodial environment and change it, I would make an argument to the Court of Appeals. I would try to do it as an appeal by right, make an argument that this is appealable by right because, in fact, the school change does change custody, even though the title of the motion doesn't say that. But the other technique I've seen people use is, and I think it happened in Lieberman at the time it was a different court rule, but there was the motion for school change and a modification of parenting time.
It was.
So by having more than one thing in your motion, even if it's not in the title, but if it's in the request for relief, to be more obvious about what you're looking for, kind of helps for the appeal. But appellate attorneys can deal with whatever is handed their way. But it does make a difference potentially, like whether your client will be able to pursue an appeal by right or not, or whether.
Lisa, can I ask you a question about that?
Yeah. Absolutely.
How as practitioners, we all have that catch-all language in our request for relief. What do we say? What is it? Any other
relief justified.
Any other relief deemed just and equitable by this court. weird question, but could you use that catch-all language to say, so let's say the title doesn't say it's a change of parenting time, or, it just says motion to change school district. The relief does not request modification of parenting time, but you have that catch-all, any other relief deemed just and equitable by the court.
So if I had nothing else, I would use that. And
Okay.
then I tie it in with the order and what the order actually does. What I've done more often though, is a motion called one thing, like parenting time or school, at the request for relief talks about, hey, we want you to change custody too, or we want to have 50-50 parenting time. It includes some sort of language in the relief section that really shows that what it is a change of custody. And I've often relied on that kind of language, even if the motion title is not what I would want it to be. But if the school change does change the established custodial environment, I would be very grateful if that language, any other relief justified, I would rely on it. I haven't had to do that, but I would if I didn't have anything other way to get it in. And there's no guarantee. I think the court has been has been inconsistent. The Court of Appeals, we've been struggling a lot with the new rule, and a lot of clients don't have appeals by right that used to have appeals by right. But the reality is there can still be an application pursued. And the other reality is that when it's a school change issue, sometimes the application avenue is going to be faster than an appeal by right. Now that really only helps you if it's like a legal issue, like maybe the judge just messed up the law, and maybe the judge changed custody and changed schools, but didn't use the right analysis and just applied the preponderance standard. That's an example where maybe an emergency application could get it back, and get it fixed more quickly. But if it's like more of a factual issue, you might get your application granted. Of course, there's no guarantee, but you might get your application granted, but then you're going to be on the normal track for an appeal by right. So you're taking a risk that it could be faster, or it could be a little bit slower because they have to first grant leave, and then you're on the normal track. So it is an issue, especially when you're dealing with the school changes. When a school has been changed, the chances of you stopping that child from moving to that new school is going to be really hard. I mean, you have to and I think the expectations of the client, they have to understand that they're going to have to live with the situation at least for one semester, if not for the full school year, until it can be resolved on appeal. And that's just the reality of it. If the school change was denied, well, that at least means the child's current life is not disrupted. I mean, for whatever it's worth, it's not disrupted for just 1 year or one semester until the appeals court can work it out and get it back to the trial court. But of course, there could be other reasons why keeping the child in that school is not a good thing either. So there's a lot to think about for appeal. And I don't want to, monopolize the conversation because this is more about Liisa and her tips for us. So, but there is one more case, and I think this is relevant to Kristen's comment about the whole initial school decision. Because there's been so many cases that we've seen in Michigan where the parents have 50-50 custody. Well, that's what happened in the Griffin v. Griffin case that came out a couple years ago. And the parents lived in different states. One parent lived in Holt, the other parent lived in Indiana, I think. And then it's time for the child to go to school. And that's when the problems start, because clearly there's no compromise. Either the child's going to go to school in Michigan or the child's going to go to school in Indiana. There's no middle road. It has to be one or the other. And that means, because of the distance, it means one parent's going to be a weekend parent or less, or a summer parent, and the other parent's going to be the full, physical custodian, dealing with the child on a day-to-day basis. And that opinion, are you familiar with that case, Liisa?
I actually did not have time to read it.
That's okay. So it was really, I think, kind of an odd opinion. I'm going to try to, I have a little summary of it here, but I'm trying to find the relevant language, because the trial court said that a change of custody would alter the established custodial environment. It only needed to apply the preponderance of the standard, because the parents have the same burden of proof and the change must be made. They have, there's nothing I can do. Somebody has to win, somebody has to lose. So the judge applied the preponderance standard. The Court of Appeals disagreed with that and reversed. But I'm not sure I understand the Court of Appeals, like what to do. The instructions it gave to the trial court, I thought were confusing. But this is going to come up when in those cases where the court has to make a decision. Somebody's going to win and somebody's going to lose because a child has to start school somewhere. The Court of Appeals said by applying the preponderance of the evidence standard, the trial court went against the clear language of the statute requiring clear and convincing evidence. Okay, I get that. But the Court of Appeals recognized the unique situation where both parties moved. So both parties moved for a change of custody in addition to there being a school change motion. So that does happen a lot where both one parent files a school change motion, the other parent's like, well, fine, I'm going to ask for custody.
Correct.
Keep the child where they are. The Court of Appeals said that given the facts presented in the trial court, it is arguable that when compared to each other, neither the father's proposed change nor the mother's proposed change was, by clear and convincing evidence, superior to the other's proposal. So what does a trial judge do when a decision has to be made? One party has to win and one party has to lose, and neither party has clear and convincing evidence. And I've actually seen this come up more than once. I've also seen it in the domicile context where the judges are like, neither party has clear and convincing, but somebody's going to have to lose here. The trial court, so this is where the Court of Appeals, I think, came up with a new standard, and I'm not sure what to do with it, but I guess it works for this case. The trial court must find that the change is in the child's best interest when compared to the status quo. So there has to be clear and convincing evidence that when compared to the status quo, the change is in the child's best interest. So
but there is no status quo.
The status quo is 50-50 parenting time with the child spending 1 week in Indiana and 1 week in Michigan, not going to school. And as compared to the child going to school somewhere in one of the parent states. Under this standard, the court may adopt some or all of a party's proposal or may create a new custody arrangement on its own accord. So that's why I think the case is really confusing. Like, what do you mean it's compared to the status quo? Like, it's completely novel way of looking at it. But at the same time, what do if neither party has clear and convincing evidence? And I think arguably in that case, I looked back at the factors and the mom was favored like in 4 factors and the dad wasn't favored in any, or if he was favored in 1. Now I know it's not mathematical. We don't just count up the number of factors but there's something there, like arguably the mom in that case had the weight was really in her favor anyway, but the judge didn't feel it, maybe because maybe the factor that weighed really strongly, maybe one factor favored really strongly for dad, and the ones that mom was favored on were really not that strong, everything else being equal. Maybe that's why the judge said, hey, it's not clear and convincing. Do you have any thoughts about what to do in a situation where something has to happen, the school has to be decided, the kid has to go to school somewhere, but neither parent has clear and convincing evidence? I don't know how I would handle it.
I mean, the more you were describing what took place, the more I'm thinking the real primary focus had to just be you were battling was a custody battle. You're in a custody battle. And of course the school, that's what started it. That's what made you get to this point. But I mean, you might get to the point, Lisa, where we're talking, psychological evaluations. I don't know, but something has to tip the scales.
Yeah.
There's what they can't split the baby down the middle. It's a horrible saying, I know, but you just can't do it. And so the court is going to have to look to a factor. And, maybe it's a factor about, the willingness to foster a relationship with the other parent. I know judges tend to put a lot of weight on that factor, understandably. So, but if I'm preparing for this like I'm preparing for a custody battle. And I'm going to make sure that I have every factor nailed that I can.
So I think some people didn't hear me say the case name. So it's Griffin versus Griffin. And I don't have the site handy, but we'll be sure to include it on the takeaway materials. And it was Judge Garcia in Ingham County who decided the case. And then Lieberman versus Orr was a Clinton County case. And Piran versus Piran was, I would think, a Wayne County case.
It was Wayne County. Yeah. Lisa, thinking more about Griffin versus Griffin, if I'm litigating that case, let's just say we have 2 very good enough parents, And really everything, we're looking at a very equal situation. You might get to the point where you're going to talk about the parent's ability to assist the kid with schoolwork. Do one of the parents have a PhD and the other one's a high school grad? And I don't mean to say that it makes you a lesser parent. That's not how I feel personally. But if we're engaged in a battle like this and we're getting to the point where it's so difficult for a judge to make a determination, it may come down to things like who is better equipped to help guide the child through his or her educational years.
And it may not just be, Lisa, it may not just be each of the parents' educations or backgrounds, but it may be who's available to be at home
Absolutely.
to help the child with homework, right?
Exactly.
That may not be the person with the PhD in economics. It might be somebody else who maybe has, a little bit of college or whatever.
You're right.
Child. So, and depending on the issues the child has, because some children need a lot more assistance, just for focusing purposes, not necessarily not smart, but they just have trouble like focusing and having a process. And they might need to have, depending on their age, might need to have somebody like sitting there with them to help. And what about, it's not just about the parents, it's about what other support people.
You just took that.
Let's talk about that.
You just took that right out of my head. I was like thinking your support system, or what's the support system? Because again, you're looking at a case like this, it's a custody case. And what are you going to do in a custody case? You're going to talk about, who is there to help, who's there to second chair, who's, takes a village. Where's your village? Who's going to help this parent? So it could be little things like that make all the difference in the world when the judge issues his or her opinion.
Well, and it's not just helping a support people in the family to help with homework, but it's also like if there's an issue with pickups and drop off to school or bringing the kids to extracurricular activities, and who's going to be better equipped to make sure that happens in a consistent fashion. And if one person, if one parent works 80 hours a week and maybe has a new spouse, is it going to be between the new spouse being basically, and this is something I definitely see a lot, where the new spouse is super involved, maybe is a great person, a great step parent. But when it's between that person doing a lot of the schooling assistance versus a parent, I mean, do the courts give any weight to that?
Yes, they do. We always look to parent first if we can. First, can we find a parent? Is there an available parent? And then if not, a step parent, a grandma, a grandpa, anymore. But yeah, in cases, if it's going to be that close of a call, then that's you have to make sure that goes back to, I hate to do this to you, but it goes back to your meetings with your client. You may need to get more information from them than you're even thinking. You need to get the whole story.
Whole picture, right?
Yeah.
And I think it also goes back to framing client expectations about what's involved with put together a proper school change motion. How much time is involved? I mean, I don't know the answer to this. Obviously, I have never prepared a school change motion before. But like, how much investigation goes into it on your part as an attorney, and how much work do you anticipate it taking, from a resource perspective?
I find that that you actually put a lot of time into these cases, and for all of you out there, as much as you love your job, it still is a job. And one thing you have to keep in mind is, the cost. How much time are you putting into this? Can the client afford your services? And I know it's not what this is about, but make sure you take enough, upfront, or more importantly than you taking enough upfront, make sure the client understands really what this is going to cost. Again, a lot of clients go into this, but I object, I go to the judge, it's over, boom, boom, boom. They need to understand this is a full evidentiary hearing. And really, counselors, you're going to put a lot of time into this.
Okay, one last question, and then we're out of time. Have you seen judges interview the child about the school issue? Is that
absolutely
practice? Okay.
Depending on their age, if we're talking first year kindergarten, no, absolutely they're going to interview the child or the children. And I think that most judges, I find, put a lot of weight into that. I really do. So, and I think that's important. Again, child-centric.
And then are usually the judges asking for that? Is that something one of the parents is like putting out there?
if the judge doesn't ask, you should ask. But I've never, and I mean never, had a case where the judge with a child who's already old enough to be interviewed, where the judge has not asked to speak with the child. And obviously, as you all know, it's an in-camera review. Neither parent's going to know what the child said, but the judge, when a child is mature enough and old enough, the judge is going to want to speak with that child.
Right. Well, Liisa, this has been so fabulous. Thank you so much for all your insights today.
Thank you.
And thank you for everybody for attending. And we will be circulating some takeaways in a recording. I think the recording gets circulated sooner, and then the takeaways can be next week, because we actually need to spend a little time making sure we have the accurate information to share with you. So if you have a school change motion, you might want to wait 1 week to file. But otherwise, watch the recording again and see if you can understand what cases we're talking about. Thank you so much, everybody. You guys have a great afternoon. And just to remind you, we have another webinar next month. I think it's on legal custody. I can't remember anymore. I'm sorry. It's going to be on some flyer. I think Trish Haas is joining us. I'm really excited about that. Yeah. Okay. So we'll see you next month. And again, thank you, Liisa. I really appreciate your time today.
Thank you, Liisa. All right. Thank you, everyone. Bye.